This is TLV1.
The Tel Aviv Review.
Hello and welcome to the Tel Aviv Review, a program dedicated to the word, to the thought and to debate, brought to you by the Van Leer Jerusalem Institute, which promotes humanistic, democratic and liberal values in the social discourse in Israel. I am Gilad Halpern.
And I'm Dahlia Shenlin. Every week we'll be talking about books and research and other things that have caught our attention. Our guest today is Sir Geoffrey Nice. He was the lead prosecutor in 3 cases in the International Criminal Tribunal for the Former Yugoslavia, the ICTY, between 1998 and 2006, and he led the prosecution of Slobodan Milosevic, former president of Serbia, sometimes called the Butcher of the Balkans. Sir Geoffrey Nice has worked on cases at the International Criminal Court, Sudan, Kenya, Libya. He's done pro bono work for victims groups from Iran, Burma, and North Korea, and he's been a part-time judge since 1984, sitting at the Old Bailey and in other jurisdictions, tribunals and inquiries. It's a long bio, but he's done a lot. We're talking today about his new book, Justice for All and How to Achieve It, Citizens, Lawyers, and the Law in the Age of Human Rights. Recently published by Scala Arts and Heritage Publishers Limited in 2017. Sir Geoffrey Nice, thank you so much for being on the show.
My pleasure.
I want to start with talking about the idea of international justice in general. There's controversy around it, and your deep expertise at the ICTY casts light on the problem of politicization of justice, which you talk about in the book. And just for people who aren't familiar with the question, one easy example is that every time there's been a verdict specifically at the ICTY, one side of the conflict feels persecuted, politically persecuted. Why is the ICTY convicting us? And the other side says the verdict wasn't tough enough. But I think you conclude in the book that international justice for war crimes has had a range of positive effects. Can you talk us through some of those benefits, despite all this criticism of politicization that international justice has brought to the world?
ICTY and also the sister tribunal for Rwanda, the ICTR, have had at least 2 significant, very important, positive effects. Whatever the reservations about individual judgments and about political interference. And I'll come to the most important one after I deal with the second one. The second one is that they've each laid down immense records of evidence that would not otherwise have been available about these conflicts, either for a very long time or maybe ever. And those records are important because they may be useful in resisting future attempts to interfere with history, to rewrite history in the furtherance of some political objective, as well as being valuable in their own right as a matter of history and as a record of how mass atrocities come to be committed by ordinary men and women in armed conflicts. But you know, the other effect, and arguably the most important, is one that is not regularly referred to, and it is this. These tribunals were established in 1993, and pretty much at a stroke, they changed the expectation of the ordinary world citizen, who now says, send him or her to the Hague or wherever they think these trials may be dealt with. And until 1993, you know, nobody said that because there was nowhere to send them. Now, this change of expectation, in my view, must be a really good thing because the view of the citizen drives the politicians and the politicians create the institutions that maybe deal with war crimes in courts or in other ways. The risk is that if these courts don't continue in some form or other and successfully, that expectation will disappear.
But you raise a very interesting point, which is my next question. There has been so much hope that the idea of international justice and specifically transitional justice will somehow be linked to peace, will help stop wars, prevent atrocities, precisely because people know, leaders and the public, that we may be going to The Hague. And you make this connection, you talk about it, but after more than 20 years of what I think is arguably the most elaborate system of international justice that's been in place in history, why do we see so much war? I mean, I've been asked this also about this issue. Syria, even now the Rohingya, which you write about in your book as well, and the atrocities going on against them. Has there actually been a connection between the development and increasingly elaborate system of international justice and a decrease in war and atrocities? And if not, why not?
Probably not. At best, probably anecdotal, that there may be warlords in Africa or elsewhere who occasionally express concern about being arrested and tried. Why not? Because trying people for criminal offences is not in itself something that's likely to bring reconciliation. It's not aimed at reconciliation. And if your listeners think that's a startling proposition, they need only ask themselves, well, when we have our state try a rapist or a house burglar, is it in order to bring the rapist and the victim, the house burglar and the householder together? No, it's not. It's to keep them apart, as a minimum. So it's not surprising that justice systems in themselves may not bring peace or change the landscape of war and peace. But I think many people would say, if you're going to have other mechanisms that can reduce conflict, then a background of a reliable justice system is either an essential or an extremely valuable part of that, because individuals will say, okay, whatever's happening to make us like our neighbours more, we also know there's a background of a justice system. It doesn't answer your first part of your question, but I think you want to ask me something else.
You say in the book that international courts are seemingly similar to national courts, except that they're not. Can you map out the difference for us?
Well, certainly, yes. It's a topic that has interested me for a long time. National courts, first of all, are readily understood by the constituency that they serve. And the constituency makes the laws. It applies the laws through its politicians and its lawyers, and if it's an offender, it receives the brunt of the law, and if it's a victim, it may receive some compensation. So it's a completely well-formed system of justice serving whichever particular country it is. Now, international war crimes trials do very little by way of these things. They may, and this is, I think, the only way in which they're truly similar, they may serve a retribution, a general retributive purpose, in that they may, as I've just suggested, have warlords around the world being a bit cautious about going into conflict. But they do none of the other things that national jurisdiction trials really do. And that, I think, is what distinguishes them. So let me just think about that a little bit more. The purpose of a national criminal trial in most countries is retribution, deterrence, and rehabilitation of the offender. Well, deterrence, yes, I hope I said deterrence and not retribution. Deterrence is the arguably single common factor. Retribution, sending somebody to jail for however many years for 8,000 deaths is not retribution at all. And rehabilitation, war criminals don't need rehabilitation. They're doing things on a one-off basis. They're dentists, doctors, film directors, as we know from a case at the ICTY last year.
Which we will talk about. But ultimately what you're saying is ordinary people.
They're just ordinary people. And that they don't need rehabilitating. Having made their one mistake, they're not going to do it again. I mean, there may be exceptions in the case of mercenaries, but it isn't going to happen again. So there are these great differences. And the problem is that because they look similar, a citizen who's not specially interested in these things thinks they're working or doing the same thing, and they're not.
Well, since you raised it, I have to ask you about the most recent and dramatic developments at the ICTY. I mean, everybody thought the most dramatic moment, I think, would be the conviction of Ratko Mladic, the Bosnian Serb general held responsible for the genocide in Srebrenica, which looks sort of like justice done. But of course, it takes another Balkan to upstage him, and sure enough, Slobodan Praljak committed suicide right there in the courtroom, even though some of his convictions were overturned, but his jail time wasn't lowered. I bet the judges have seen it all. What does this say on a symbolic level, I mean, about the ICTY? Success, failure? Does this stunning incident symbolize something about, can the court, how does the court make sense of this?
This operatic conclusion
theatrical.
To 23 years, an overextended process. I don't actually think it should say anything, but I think it will. And I think it will because the true value effect of the ICTY is going to be a subject for future generations to analyse. It closes its doors, it'll pass into oblivion, and maybe in 10, 20, 30 years' time, scholars will work out what it really did. Until then, all that people will remember is Praljak, They might remember that Mladic was convicted of genocide and think that's altogether a good thing. We'll perhaps come back to that because it's a very important and not very good judgment. Or they may remember Milosevic dying or whatever happened to him before
you said it
before the trial concluded. But that's about all they'll remember. And in a way, it's unfortunate that we had such an operatic conclusion, because it will distract attention. But I fear that even if attention was properly focused, it would never be intelligently analytical. Why that is? Partly because the process has just gone on too long and has been mismanaged accidentally. I don't mean necessarily intentionally, mismanaged in various ways. It doesn't work in the way that Nuremberg worked, trying 20-plus people in 8 months or 9 months. That was an event, I think, that people were able more easily to understand and to carry away with them. They also, critically, they had some very important courtroom photographs that imprinted the whole process on their retina. Everyone's retina. You can show a picture of Goering in court round the world, flash it at them, take it away, and most intelligent people know what it is. It's an extraordinarily powerful image. We don't have that for the ICTY, and therefore, who knows?
Before we continue on the topic of Yugoslavia that Dalia would so happily spend the rest of the day on, I'd like to ask you a bit about the archaeology, the history of international law. You discuss in the book how it emerged as of the late 19th century. And of course, Nuremberg was a milestone in that journey. And I want to ask you about what you said in the beginning of this conversation about the ICTY and ICTR being some sort of turning point in our understanding. What really were the events that led to that turning point, to that culmination, perhaps?
The events were, I suppose, the first formulation of law by the American Civil War Lincoln-side Lieber Code in the mid-19th century, by the Hague and Geneva Conventions of the late 19th century, early 20th century, by some sample trials of under 20 Germans only after the First World War, the Kaiser escaping, although it was expected to try him. The Versailles Convention allowed for that specifically, but he hopped it and got free in Holland. And then the Nuremberg trials, which were followed by some follow-on trials, but interestingly didn't last for long. There may be two reasons why they didn't last for long. One, the Cold War turned enemies into friends and friends into enemies, and possibly also with that great dramatic trial of the 20-plus leaders, the appetite for this kind of process declined and didn't rise again, really, for a very long time. I know we had Eichmann in Jerusalem. That was about it. So those are the landmark events, or some of them. And it's worth starting in the middle of the 19th century because, although that may seem a long time ago, it's actually very recent. And therefore, it's not surprising if modern processes that are built on that limited experience are still experimental, making mistakes, and we hope going on to get better. The really critical part, or a really critical part of the development, in my view, is that right from the beginning of the trials, it was individual criminal responsibility that was focused on.
As opposed to state responsibility?
Yes. And at first sight, this looked like a jolly good idea. Yes, you want to try Goering, you would like to try Hitler, and yes, you want to try Pol Pot, but he's not around, and so on. But, as your intervention indicates, it has also served to let states off the hook. And there's a very important example of this in the Yugoslav trials, but generally, before we come to the important example, often it is a state, not just the leader of a state, that is responsible through its collective leadership for bad things in war. And so far, generally, that reality is avoided by these criminal processes. The only way you can bring a state to book for war crimes is at the International Court of Justice, state civil cases under the Genocide Convention. And people who are states that have tried to use that have so far had very unhappy, limited success or substantial failure.
Because you mentioned the Eichmann trial, and I think also because Hannah Arendt does sort of hang over your book in a way. I mean, she's raised at various points. Let's go to her observations of Eichmann. I mean, she observed him so closely and famously concluded that he represented the banality of evil. You came face to face with Milosevic. And from this sort of intimate observation, you mentioned his business suits and his intelligence, but always put to the service of himself. And you also point out that you don't think he had any particular hard political ideology other than power. Does he represent to you a sort of banality of evil in Arendt's sense?
I'm not sure whether I would go so far as to borrow as to apply her phrase, and I've never done so. And incidentally,
no, you didn't.
I understand that. And incidentally, I never use any of the other phrases, such as the one by which you opened the program, Butcher of the Balkans, because I actually think that labeling, although attractive and useful for some purposes, is unhelpful in others. And I never allowed labels to be used about Milosevic in my team or in the office. I wouldn't respond if labels were used. He was either the defendant or he was Milosevic. That's the only terms by which he could be referred to. And that maintains a measure of objectivity, I hope, in the work you do and stops you getting carried away emotionally. Nevertheless, to pick up on your question and try and use Hannah Arendt's labeling,
her analysis, really.
Her analysis, yes. He certainly represented some extraordinary banality. Yes, he did. But I think your listeners may find the very short arc of his history as most interesting. He was a lawyer, he was a communist apparatchik, a banker, spoke very good English.
Even enamored of American capitalism in a way for
all
a phase,
of that,
yes.
And he favored retention of the former Yugoslavia. Nothing wrong with that. Nothing wrong at all. You can't complain about that. He was brought to power by others who sought a champion. You can see him enjoying it in his occasional very big speeches, first at Gazi Mestan and then in Belgrade. And by the end of the arc, he's a common murderer. When he had his former mentor, the man who effectively brought him to his position, murdered in cold blood because this guy was likely to become a political opponent. And so whether he contained within him something that enabled this evil to emerge that was special to him, I don't know. I suspect it is the sort of thing that can happen to many people, not, I hope, to every person. And so if that makes the application of the term banality, ordinariness, baseness appropriate, then yes, he was an ordinary guy who was turned evil by events and by his own decisions.
You raised this idea of labeling, and you have protested against it, which I accept completely as a critique. And in a way, the book, you try to bring the understanding of international law and international justice to, regular readers. It's a very readable book. It's very narrative. You give a lot of explanation. But on the other hand, can the law ever really be subject to that kind of scrutiny of the media, which is generally, in the popular discourse, trying to simplify these things? And, the issues are so subtle, so complex, sometimes emotionally removed, when in the popular imagination, people want justice and they want it now, and it's sort of inherently reductionist. How do you meet that challenge?
I'm not sure it's an answer to your question, but there's a point that I think is very important, and that is that law must be understood by the people it serves if it's to have a valued presence and a valuable future. And again, test it by reference to your own domestic law in any country. Okay, the people may not know the intricacies of law about import-export guarantees or the LIBOR rate or whatever else it is in the City of London, but they have a very straightforward understanding of murder and burglary and speeding offences and all sorts of things like that. And that's when the law works at its best. Its constituency understands what it is, and it all fits together. If the international law is so complex as not to be understandable, then it's arguably going to be, by that very factor, the author of its own downfall or limited future. And you can take two really important examples. Genocide was provided to the public by lawyers and politicians for arguably very cynical reasons. Not Lemkin, he was terrific, who created the word and forced through the Genocide Convention. But the background of political cynicism on the part of the Americans and probably the Brits as well, that led to the need to create the concept of genocide is perhaps rather deplorable. But for whatever reason, lawyers and politicians gave the public the concept of genocide, which is extremely hard to understand.
In the legal sense.
In the legal sense. But and for long enough, I thought that really means you shouldn't use it as an offence and you shouldn't charge it. And then I thought, no, that's wrong. You've given this term to the public. The public are going to use it. And frankly, if the public use it in a way slightly differently or even significantly different from how lawyers intend, bad luck on the lawyers. At some stage, you've got to be able to accommodate both understandings.
No, but you do expect the legal realm to be somewhat removed from popular sentiments, unlike the media or politics. I mean, what happens when, okay, it's one thing if they understand it and it's important to promote that understanding, but what if, like, all sorts of popular sentiments start affecting the legal processes?
Well,
what do you do then?
Your question is mildly tendentious, suggesting that the public shouldn't be able to rule the law. And as you will know, I think from somewhere in my book, but I'm not sure, maybe elsewhere, I don't necessarily hold to that view, because the law is the servant of the people are not the servant of the law. Now, if I can come back to the other example before I return to genocide, the other example is, war crimes bandied about as a term whenever it suits people, one way or the other. And what does a war crime mean? Well, a war crime, although this is an oversimplification, is capable of comprehension by application of the term that appears only in International Committee of the Red Cross documents in terms of proportionality. And so that the ordinary public can, and this sounds almost patronizing of the ordinary public, the non-specialist public, can have some concept of a conflict that is lacks proportionality, of a response that lacks proportionality. So it's not actually impossible for reasonably complex or very complex legal concepts to have a sufficient understanding in the general reasonably educated public as to make that law valid. And the problem with genocide is that it has always been one step too complicated, I think, for general use. Interestingly enough, at the Nuremberg trials, the word was used adjectively in the
genocidal.
In the indictment. And if you look at the opening speech of Ben Ferens, who's still alive in the Einsatzgruppen trial, he, standing there at the podium, uses the word genocide twice. But it's only descriptive because the word was just coming into use. If it had stayed like that, and we'd simply fixed ourselves with crimes against humanity, widespread attacks, that would probably have been easier for people to understand. But we are in the position we've been placed by politicians and lawyers, and the public are entitled to use the term they've been given. And coming back to your point, if ultimately that leads to a change in the concept of the law, because the divergence of public and lawyers' use of the word would be too great, I'm afraid to say I don't mind, because the good is where the law is understood. The bad is where it is completely beyond understanding.
I think the temptation for politicization, just to get back to the theme we have talked about, is so big, not just to politicize, but for the public to understand some of these terms in politicized ways. I think of how often the term genocide is bandied about now, and with qualifiers and modifiers, cultural genocide. These concepts do exist in law, but they're used in popular discourse in any way possible, including, this is a bit of a stretch, but, in the recent Catalan referendum, I heard Catalonians being interviewed on, for Israeli television saying, well, because the Jews have suffered, okay, they didn't say genocide, but because you Jews have suffered, you should be on our side. Is there a cheapening and a flattening of suffering? Maybe I'm certainly not blaming international justice, but of these concepts.
In general, of the concept of justice in general.
By use of the term genocide, I don't know that it's...
Or implicit reference to it.
I stick with genocide itself. It certainly has been instrumentalized by politicians and celebrities, of course, to achieve objectives. So where Angelina Jolie slaps the label of genocide on Darfur, it sticks because it's her and because of the label. And right or wrong, that labeling may have an effect on the difficulty or otherwise of resolving the conflict in Sudan.
But in a way, that's a positive example because she brings a lot of attention to the issue by being her and by using that term, no?
It could be. Although, of course, if by that label it disturbs the balance of interest in other similarly grave conflicts to which the label can't be attached, then you could argue that it's not entirely helpful. But it's most powerful consequence. I mean, Sudan's quite a good example of this. As you possibly know, I appeared more or less for the Sudanese government, not quite, but effectively, in trying to stop the word genocide getting on the indictment against al-Bashir. Now, many academics and lawyers would say it actually wasn't genocide, it was something else. It may be similarly bad in terms of death, but genocide it wasn't. So the word genocide got onto the indictment. Now, al-Bashir had said he would resign and allow for a new regime. But now, of course, he can't. He is locked into being president, arguably slowing the process of Sudan. So the word is immensely powerful and has some good, can be used to the good, and is something of which you've got to be careful. I used it myself a long time ago in an op-ed about the Rohingya Muslims, never saying that there was genocide, but only going so far as to say, we know what the components are that bring about crimes of mass atrocities, including genocide. And beware, you in Myanmar or Burma, these elements are there. Some of these elements are there, and you've got to be careful. You don't allow them all to be there.
I mean, I certainly will agree with the power of words and understanding their impact in political and symbolic life. Let's bring it back to the politics of our region, because we are from Israel. And you have interesting chapters on the Gaza conflict between Israel and Hamas. You have several sections you wrote. One of the sections you have a co-writer. You have another chapter on the flotilla incident. I have to say that I had a little bit of a hard time coming up with your conclusions about how international justice functions and can function in this particular conflict. Can you explain what you think international justice can do here? Or is this just that we are in an ongoing conflict, we're not in a post-conflict situation, and the role is going to be limited?
I hope that from both chapters, readers would understand that my preference would be for the International Criminal Court to take hold of each of them and deal with them by findings one way or another as to whether possible offences have been committed and whether individuals need to be pursued. As we know, in neither case has that happened. Indeed, in neither case has the International Criminal Court made the first, I think, decision to get on and investigate, or it may have done in one, not in the other, which is always is consistent with political pressure or anxiety about political fallout from investigating these two events. In the one,
are these more prone to political fallout than other conflicts? Is the Israeli-Palestinian conflict more in the
Well, I'm not a
spotlight
politician and I must stick to my skill.
Fair
But
enough.
I would have thought, rather reinforced by what we've been hearing today about moving the capital of Israel to Jerusalem, I would have thought that they are particularly vulnerable to political fallouts. And they are also, of course, politically vulnerable at the ICC to political pressure, because America can, I'm afraid, apply pressure all over the place, certainly in the ICC and certainly, incidentally, in the ICTY. But just to finish this, in case there's a shortcoming in my chapter or chapters on these topics, in so far as Operation Protective Edge is concerned, which is the subject really of the first of the two
The 2014
chapters.
war between Hamas and Israel, I should say.
Yeah, I mean,
Gaza.
that's a highly complex event that's well beyond a journalist properly to say this is or this is not war crimes. Likewise, somebody like me, all you can say is, looking at the test for war crimes, looking at what you can see, this is a case that should go for judicial inquiry on both sides. And if it won't go, this is, I think, the way I end that chapter, if it won't go, is this an indication there are some conflicts that are beyond the law?
Well, I think that was my question.
Yeah, and if they are beyond the law, it's a truly horrible series of questions that follow. Does that mean you should all sit back and just let the conflict come to a bloody end and then move on some utilitarian basis, that this may actually ultimately be better than fiddling around from an outside point of view? And that's really not a question you want to ask, but you have to ask it if parties will not submit to judicial oversight.
And what is the answer?
I think he's asking a rhetorical question, Gilad.
The answer, I think you have to keep trying. And I firmly believe, whatever the real limitations there are in the International Criminal Court, and there are many, that if it had the courage to say, we will review, particularly say particularly say the Mavi Marmara, where there were 4 diverging reports, 2 from the UN and others.
The flotilla.
The flotilla case, sorry, yes. And you can see first that simply cries out for some kind of independent analysis. more, if you recall, I also said that had independent analysis been applied, it's just possible that Operation Protective Edge would never have happened.
You did imply that. I have to say I wasn't convinced. I think these parties are committed to going to war every so often. But I want to start wrapping up by coming back to some of the theoretical angles. You know, in the introduction, you raised some of the most heart-wrenching historic cases of justice applied, but injustice being done. I don't know if you phrase it like that, but I thought it was a very important point. You mentioned the cases of Oscar Wilde, Alan Turing.
Yeah.
And I think that you raise a fascinating question, which is, how can any of us step outside the influences on our lives, our heroes, our own laws, our context, and try to think completely independently? I'm going to quote you for a moment. You say, how can any of us, guided or not by religion or by our nation's laws, think sufficiently freely to evaluate our own lives and not be trapped by standards set by others? Do you think that's the goal of international justice, or do you have another recommendation for how we can do this?
No, I don't think that's the goal of international justice. I think that's the goal or objective of the thoughtful human being in, first of all, assessing what he reads, sees, and observes, and also in trying to judge himself. What international justice should be doing, I think, is meeting those pretty obvious problems, and the problems of different standards applying over time and over geography, different over time and space, and trying to look for essential acts that are wrongful and going about proving them. Now, this goes right to the heart of the human rights history and debate. Are human rights intrinsic to our humanity, so that they exist here or in the forest in Borneo, where the child is born to people who have been quite recently, or Sarawak, I'm not sure, quite recently cannibals? Are these rights that essential, God-given or otherwise? And if so, and we hope they are, or at least that they can be treated in that way, should they form the bedrock of international oversight through courts? And I think that can be the case. And apart from the right to life, you've got to extend that, because there's still a right to kill in conflict, which is unhappy, unpleasant, but nevertheless a present reality. But you've got to narrow down, the court has got to narrow down so that the public can understand what's really at the heart of goodness and badness.
Over the last couple of years, we've seen the decline, a retreat in the belief in progressive causes, in democracy, liberalism, Trump, Brexit, many, many other examples. Do you see international justice having a similar fate?
I hope not. But
our listeners can't see the face that you just made, the eyebrows that were lifted.
I hope not. But it's going to need a great deal of commitment by a large number of people and impetus of NGOs and journalists and others to see that what you allow for doesn't happen. And here's a problem, isn't there, that justice is very low on every politician's agenda. At the bottom of everyone's agenda is the victim. The victims count for nothing, I'm afraid, when a political interest collides with the interests of a victim. And moving up from victims to the generalized concept of justice, it's all right when you can use it for an instrumental purpose. You can stand up at the UN and say, oh, they're committing war crimes, or they're not, or whatever you like. But in fact, it's still subservient to politics. And when you look at the ICTY, and we haven't covered this, or the ICJ, and certainly the ICC, where there are pretty well-evidenced examples, or even better, Cambodia, where there are evidenced examples of political interference in the justice process, allowed by the international community because of the way it runs these courts, because of their political history, or the history of their political creation. You can see that perhaps the most important objective we should all have is that these courts can be freed of political interference. And I would say for your listeners as well, although you didn't ask me this, that the greatest right we should now be, or the right that we should now be seeking to enforce is not written in the 1948 Declaration, but it's the right of the citizen to know. And I hope that will become increasingly obvious as a universal right. People in Srebrenica should not have had to wait 23 years for a very imperfect account of what happened. The perfect account being kept from them by Serbia, but also by other countries who have hidden evidence because they don't want to reveal it. If I was a relation of one of those people killed in Srebrenica, and I wanted to know precisely what happened, how Serbia was involved, how the West was involved in waving the Srebrenica attack through and not doing what it could to stop it for geopolitical reasons, whatever geopolitical means, I'm never quite sure. If I was one of those victims, I would say, thank you very much. That's not justice. My justice is that I want to know. And that's what we should aim for.
That's Sir Geoffrey Nice talking about his book, Justice for All and How to Achieve It, Citizens, Lawyers, and the Law in the Age of Human Rights. Thank you so much for being on the show.
My pleasure.
And also big thanks to Gizem Ozdemir, our sound engineer, to Tai Shelem, our producer, and to the Van Leer Institute for their generous support. We would also like to thank Peter Frey and Carrie Shapiro and the Romay Foundation, who made a very generous contribution to the Tel Aviv Review. You too can help us survive, just like Blanche Dubois. The Tel Aviv Review relies on the kindness of strangers. So if you want to be kind, don't be a stranger, write to us, Gilad, Gilad, at tlv1.fm, and we'll tell you what to do. In the meantime, don't forget to check out our archive on www.tlv1.fm/podcasts. There are almost 400 interviews to keep you busy, entertained, and potentially annoyed and hopeful after today's interview. We would also like you to like us on Facebook. Our page is called the Tel Aviv Review Ideas from Israel. And follow me and Dalia on Twitter and Facebook. Join us again next week for another edition of the Tel Aviv Review. And until then, goodbye.